Hi everyone. In this session today we will talk about importance of intellectual property for business. As you know that intellectual property is creation of human mind. Any creation of human mind which is not replication of something which is already existing or such creation has value. You may think of registering it in a right legal framework. Intellectual property, depending upon its type, may take various forms and various shapes. For example, it may be a design of a product and that is aesthetic look and feel. It may be a computer program, composition or recipe of a product like Coca-Cola, or it may be product or process like the vaccine composition, it may be a drug formulation, it may be a machine, steam engine. So depending upon the kind of intellectual property you have, there are right ways to protect or register them. If you look at the top brands and their global value, a lot of value is added to overall valuation of company because of intellectual property these companies they have. You take example of any big company today like Amazon, Apple, Microsoft, Google, Facebook, McDonald's, Mastercard. All these companies they have great value, but majority of this value comes from their intellectual property assets. So this indicates that for any business, small, medium size or large enterprise, protection of new intellectual property or protection of innovations is extremely important in today's times. Depending upon the type of intellectual property, it can be protected either by registering it or maintaining confidentiality of it. So maintaining confidentiality is at times considered to be little difficult than registration in the form of patent, but there are still ways and means to protect your intellectual property as trade secret as well. Patent is one of the most important forms of intellectual property. The word patent itself means to disclose. That means when you file for a patent, you have to disclose about your invention to the government, respective patent office. So in India, it is Indian Patent Office. So similarly, in the US, it is US Patent Office. So you have to document your invention in a particular format prescribed by the patent office, and then you have to submit it. And after scrutiny, if your invention is found to be worth getting a patent, then patent is granted by the government. So patent is granted for the invention, which may be a product or a process or both. Term of patent is 20 years from the date of filing. So if you file your patent application today, exactly upon expiry of 20 years, your patent gets expired. That is a time when others can use your patented invention without your consent. It is very interesting to note that patent rights are territorial, which means that your Indian patent is valid only in India. And if you want protection in the US or any other country across the globe, then you have to file your patent application in that particular country. But generally speaking, your patent rights are completely territorial, it's country specific. Second form of intellectual property is copyright. This is a kind of right which is granted to the works of authorship. So you have very wide range of creativity and wide range of intellectual property which gets registered as copyright. For example, literary work wherein you can protect books, periodicals, journals, even computer programs, they are registered as literary work. Then you have artistic work, cinematic, music, so all these categories are available in copyright to have registration. In India, we have one copyright office that is in Delhi. And a good thing about copyright law is that there is something called as Berne Convention. So if you register your copyright in one member state of Berne Convention, then you automatically have protection in all member states of Berne Convention. And as of today, around 180 plus countries they are member of Berne Convention, which means that if you register your copyright in India or US, it is valid in close to 180 plus countries. So that makes copyright a very handy and a good way of protecting your intellectual property. You are well aware of trademark as intellectual property. So trademark is nothing but name of the business, name of the product, name of the service. So we also call trademark as a brand name. So trademark law gives protection on the name and logo, tagline if there is any tagline. So trademark registration is mandatory for the business. Like today or tomorrow, you have to register your trademark. And it is important to perform a trademark search before you finalize the trademark which you are going to use with respect to your service, company, or the product, in order to make sure that your trademark is not similar to any existing trademark. Because if there is great similarity, then you may have problems later on in the form of, the registration process may have lots of objections. You may expect a lot of opposition from the other companies. So trademark search is the first step when you coin your trademark. And after that, you can think of registration of your trademark. Design is a very interesting form of intellectual property which is granted to aesthetic look and feel of the product. It is interesting to know that design law doesn't have anything to do with functionality of the product. It only emphasizes on design of the product. Now, in the picture you can see it is toothpaste. Now the product remains the same, but it is only design of the cap which makes it eligible to be registered as design of a chair, design of a cycle. So there are lots of things you can register as design. For example, you may have a design of your watch, design of a mouse. So design can be registered for any product which has good aesthetic look and feel. Geographical indication is a kind of intellectual property which is granted to specialty of the places. It is a sign used on products that have a specific geographical origin and possessive qualities or a reputation that are due to that origin. So, specialty of a place is registered as geographical indication. In India, every state has one or the other geographical indication, and Karnataka is the state with maximum number of geographical indications registered in its name. I'll give you some more examples. Pashmina shawl is registered geographical indication. Mysore silk, Bidri work, Lucknow chicken, Kullu shawls, Madhubani painting. So these all are specialties of the places and they are registered as geographical indications. So once they are registered as GI, then their reputation, authenticity, and the market value increases. So it is very nice for the communities to have the geographical indications registered in their name, their state's name. Traditional knowledge refers to know-how, skills, and practices that are developed, sustained, and passed on from generation to generation within a community, often forming part of its culture and spiritual identity. Traditional knowledge is not registered, but it is protected by documentation and publication so that others cannot claim patent rights over it. So it is very different aspect of traditional knowledge that it is not registered. We emphasize on registration of trademark, registration of copyright, registration of a patent. But traditional knowledge is a kind of intellectual property which is not registered. It is only protected by documentation and publication. Some examples of traditional knowledge are folk dances, folk songs, usage of turmeric for wound healing, usage of neem as antiseptic. So these all are traditional knowledge, and in India, every state has its own traditional knowledge. And I also want to emphasize here on one aspect of traditional knowledge that in patent law, there is a clause saying that traditional knowledge of any country cannot be registered as a patent. So, if you are planning to go for a patent which is based on any knowledge available in the community, then you must always verify whether is it right thing to go for a patent or not. Because if it is traditional knowledge of a state, then getting patent on that is extremely difficult, or you can say that it is almost impossible, because in India we have a complete guideline on what kind of patents you can register based on traditional knowledge. Then comes trade secret, again, a very unique form of IP. So, trade secret is also not registered, because in order to register your intellectual property, you have to disclose it. Since it is a secret, you cannot disclose it, so you cannot register it. So, best way of protecting trade secret is to have guidelines, policies, agreements in your organization to see how you can maintain secrecy of it. Coca-Cola is a most popular example. So no no discussion on trade secret is complete without mention of Coca-Cola. So it has been maintained as a trade secret for more than 100 years now. And how they maintain it, why they maintain it, what are the policies, what are the physical restrictions to access the area where some secret work is going on. So you need to have beautiful guidelines, concrete guidelines, policies, agreements to protect trade secrets in your company. And believe me, every company has one or the other form of trade secret, but they realize value of trade secret only after they lose it. So trade secret has value. It is not known to public. It is not registered because you cannot disclose it, so you can't register it. Uh, so trade secret, when you decide to maintain any information of your company as a trade secret, you must make sure that trade secret should be a kind of knowledge which is not in public domain, which has value, and also it should be very difficult, or it should be almost impossible to reverse engineer your trade secret. So if your product is in the market and you call a trade secret in the recipe, but if I can reverse engineer it as a user, then it is not a good trade secret. So trade secret should be such that it should be almost impossible for the end user to reverse engineer a trade secret. 5 forms of intellectual property are very important for business. Patent, wherein you can protect product or process. Copyright, most businesses they have their software codes to be registered as copyright, but otherwise copyright is available to be registered for 5 or 6 classes. Trademark, every company will have trademark, so today or tomorrow you have to register it, sooner the better. But do put trademark search before finalizing your trademark. Then comes design, wherein aesthetic look and feel of the product should be registered. Trade secret or confidential information, again, almost every company has. So since you can't register it, you have to find out the ways to protect it. And one product can have multiple protections. A single product may have a patent. It, aesthetic look and feel of packaging may be a design. Name of the product may be a trademark, the user manual may be a copyright, and some information inside the product may be trade secret or confidential information. So it is very much possible for a single product to have all forms of IPs in it. Now comes the question, how to protect intellectual property. So the best way to protect intellectual property is either by registration. You can register in the form of patent, copyright, trademark, or design. If you don't want to register any of the IPs as patent, trademark, or copyright design, you can protect it by legal contracts also. Suppose it is a trade secret and you're supposed to disclose it to somebody, then you have to have legal contract, and you can maintain secrecy of it. So once you maintain secrecy of it, then again you can just find out which is the best way of protecting. You must seek legal assistance to do so if required, but these three are most common ways to protect your intellectual property, either by registration or by having legal contracts or by maintaining secrecy of it. If you protect your intellectual property, there are lots of advantages. The first is that you can prevent others from replicating or copying it. Then secondly, you get recognition in the market. You can brand your products better. And if there is anyone copying your product or your intellectual property in the market, you can enforce your rights. And having intellectual property definitely adds to a valuation of your company. Once you own intellectual property, you can also explore licensing of your intellectual property to others. So that could be your additional source of revenue. So these are the advantages of registration of your intellectual property. There are 4 important aspects of intellectual property. That is, you must protect it. Okay, so protection, as I told you, is by having registration, legal agreements, or by maintaining secrecy of it. So you must protect your intellectual property. That's the first step. So once protection is in place, then you can think of monetizing it by using it yourself or licensing it to others. And once registration is done and you find somebody copying your intellectual property, then you can enforce your right and take legal action against such companies. We always talk about the protection of our own intellectual property, but we forget that uh, infringement of third parties' IP should also be prevented or minimized. So before we launch new product in the market, infringement risk assessment is very important to ensure that you are not infringing any third party's intellectual property rights. Because if you fail to protect your intellectual property, there is a loss. But if you infringe upon third parties' rights, then the loss may be very huge. So you have to be always alert and careful before using intellectual property of any third party. So IP is an important component of a business. Failure to identify and protect intellectual property may be detrimental for the business. So in order to enforce your IP rights, registration of IP is very important. I hope you found this video useful.